Here for Perez cash.
Thank you.
Here it is.
Thank you.
SJC-09972, Commonwealth versus Linton.
Good morning, Mr. Doyle.
Good morning. May it please the court. My name is James Doyle. I represent Damian Linton in this appeal of the first-degree murder conviction. Linton was charged with the murder of his wife. The case went to the jury on two theories: deliberate premeditation and extreme atrocity and cruelty. The jury did not return a verdict as to deliberate premeditation, however, found Linton guilty as to extreme atrocity and cruelty. The trial was dominated by questions about who did it, who committed the crime. There was a long narrative involving the relationship between Mr. Linton and his wife developed during the course of the trial. And the narrative has as one of its outstanding features an incident that had occurred 5 months before the homicide. And that's a reference to an incident in which the deceased wife said that Mr. Linton had choked her into unconsciousness. She had then revived and survived for the next 5 months. That information is conveyed completely through the hearsay of the deceased spouse. And as we say in our brief, and as was said at trial, there are a number of reasons why that incident ought not to have been admitted and why it had an important impact on this trial. The first is that as a matter of state evidentiary law, we do not believe that this statement qualified as a spontaneous utterance. As the narrative unfolded, there was an event. The victim, at that point distraught, called her father. Her father then drove to the scene. He arrived there about 10 minutes later. When he arrived there, he found that his daughter had found a place of security in a telephone booth outside the apartment where the defendant still was. He had a brief conversation with his daughter.
Excuse me, a telephone booth on a public street outside the apartment is a place of security?
Relative to the apartment, Your Honor, yes.
Not locked?
I'm not suggesting it is
And
a
the
matter of law.
defendant is in a rage. I wouldn't call it a place. I wonder why it's called a place of security.
It's a place of relative safety compared to the apartment where the defendant still was. In any event, the father then went to the apartment, had a colloquy with the defendant Linton, which also took some time, went back, had his daughter, he and his daughter drove back to his house. At that point, there's a conversation in which the details of the incident involving the choking come out. It's our position that that narrative, the second narrative, whatever might be admissible from the initial phone call, does not qualify as a spontaneous utterance. There was ample time for reflection. I can't give a two-sentence version of the testimony about this now because the court will want to read it as a whole. But I think when the court does read it as a whole, the court will see that although certainly the victim was upset, the predominant emotion at the time of this conversation was anger, and that there had been time for the victim to reflect, to think through a narrative, and in fact to provide a compact, coherent narrative of past events. This was not a typical spontaneous utterance. Of course, spontaneous utterance cases are always very fact-intensive, and the court will want to look at all of the facts surrounding it. However, in this situation, we believe the objection should have been sustained, that this, as a matter of state evidentiary law, didn't qualify.
The victim's mother spoke to someone about this incident as well, didn't she? The one that happened 5 months before. Did she speak to the victim and get a report from the victim, or did she speak to the defendant?
The victim's father spoke to the defendant, Your Honor. I don't recall a conversation with the mother from this immediate time frame. There were discussions during the intervening 5 months of what might have happened, what's going on in this relationship, but if there was a specific conversation with the mother on that date, I don't recall it.
But the father then called the defendant, and he admitted that he had strangled.
He admitted that he had put his hands on the throat of the victim.
And did he admit that she had become unconscious?
No.
Just that he had grabbed her by the throat?
Yes. And we also, of course, raise a constitutional argument on this point, which is not admittedly as clear. This is not plainly per se testimonial evidence. It's not a 911 call. It's not grand jury testimony. On the other hand, it is also not evidence that of statements that were made outside an understanding that testimony might later follow. It appears to be the kind of statement that would happen where the decision about whether testimony, court proceedings, public proceedings would follow had been reserved by the speaker, where this was no testimony that was made to be purely private because it was to a family member, nor to be purely public because it was offered to a police officer with the explicit settled decision to pursue public court proceedings, but nevertheless had all of the indications of something which would be available for testimony later on and used in court later on if that were to occur.
But the test that we applied in Gonsalves to third-party questioning was whether a reasonable person in the position of the speaker would have understood that this would be used for investigation and prosecution. And here, where she brought no charges, why does that not play into that analysis?
Well, because the fact that she brought no charges later does not really factor directly in a sort of one-on-one relationship into what the reasonable person knew at the time of the speaking. Many times people will make a decision to not pursue a case in court later on. 911 calls are made, testimony is given. Subsequently, the speaker will decide not to go to court, or the case will be dropped for one reason or another. Testimony does not eventuate for a myriad of reasons. But the real question is what can be inferred from the failure to testify later in regard to the consciousness of the speaker at the time the statement is made. We argue in this situation that it's certainly true that there's no settled intention to testify or to mobilize the power of the state in this question. However, we also feel that this is a case that I don't think the court has dealt with, where there's no settled determination to do otherwise. Gonsalves is a case where it looks very much more like, I want to have a private conversation with my mother. In this case, we don't believe that question had been resolved. Now, we, as to this argument, face a substantial risk of miscarriage of justice standard, because trial counsel, facing this trial in a moment when the Crawford law was not well developed, this trial occurs in 2006.
But it would be a substantial likelihood.
Substantial likelihood, yes. Did not object to this at that point. In terms of the content of the event, we believe that it was highly prejudicial, and that the prejudicial impact of this piece of narrative badly outweighed its probative value. There is an attempt at a limiting instruction, but the efficacy of the limiting instruction is minimal, and in fact we believe it has no efficacy at all. The best support I can offer the court for that argument of ours is that when the trial prosecutor attempted to mobilize this event in the trial prosecutor's closing argument, he could think of no reason that the jury could use this properly. He simply repeated the event and said, well, just remember this. What the trial judge says is, first of all, you can't use it to show that this is a criminal-type disposition. You can't use it to substitute for evidence of guilt. You can use it to show the nature of the relationship.
What about motive or state of mind?
Motive, intent, state of mind, or the nature of the relationship. And unfortunately, the phrase nature of the relationship, when the instruction is read as a whole, appears to be open to the interpretation of the nature of the relationship being the kind of relationship where he tries to strangle his wife. There isn't anything developed that presents specific inferences of why this event, which preceded the homicide by 5 months, would show motive or intent on the night of the homicide. And it does, to the extent that the motive of the relationship, as a phrase has any comment at all, appears to take away the judge's, or undermine the judge's cautions that you shouldn't use this for predisposition purposes. One interpretation that you might be able to glean from the instruction read as a whole is that you can't use this to show that he's generally predisposed to behave in a violent fashion. However, within this relationship, he's predisposed in a way that involves, among other things, assaults and attempts to strangle. Again, this was an important piece of evidence in this case in terms of the prejudicial impact it would have. The nature of the relationship, we believe, had something to do with the ultimate finding of extreme atrocity and cruelty, and that the instruction itself does not convey a permissible use. The trial prosecutor could not discern from the instruction what he would be permitted to use this for. Instead, he simply said, remember this for whatever it's worth, and if that's what the jurors did, there's a substantial likelihood that they used it in a way that would be prejudicial for the defendant, despite its relative absence of probative value.
But why is this case distinguishable from the many other cases in which we've permitted, with regard to a domestic abuse case, some evidence of prior domestic abuse?
Because this particular evidence of domestic abuse, no connection is drawn between this and the events of the night of the homicide. And the judge specifically says that this is not being used for predisposition. And the prosecutor's inability to find a way to articulate any rational basis for using this evidence, we think, is a strong indicator that in the whole context of this trial, taking the instruction as a whole and the evidence as a whole, the probative value here is minimal if it exists at all, and the prejudicial effect is very serious.
And if we do what you say we should do, would that change the existing case law with regard to the admissibility of prior bad acts in domestic abuse cases?
I think the admissibility for prior bad acts evidence in domestic abuse cases is always an extremely fact-intensive determination made on the merits of every individual case. I don't believe that this would change the rule at all. It would simply suggest that the rule has to be applied with care. I don't believe the rule now says any prior bad act within a marriage is always admissible anytime there's an event of violence later on during the course of that marriage. And so we don't think we're asking for anything in this case except a very rigorous scrutiny of the particular facts of this case and a weighing of the prejudicial impact of this, which is very large, versus the probative value, which was minimal. Having said that, and having said that we believe that the accounts of this earlier incident should not have been admitted, once they had been admitted, they should have been able to be available to form part of the calculus for whether a jury instruction on involuntary manslaughter was required in this case. That instruction was requested by the defense. The rights on that are preserved. The rule in general is that if you have to view the evidence in the light most favorable for the defendant, and viewing the evidence in that light, here there is a narrative in which the defendant at the time of this homicide may well have been contemplating simply a repeat of the earlier incident as described in the hearsay testimony.
But I understand that position, but the evidence, I gather, was not materially in dispute that whoever did strangled her to unconsciousness.
As was the statement in regard to the earlier incident.
Right, I understand. But would that not at least pose a risk of grievous bodily injury or of that which a reasonable person would understand produces a substantial likelihood of death or grievous bodily harm?
We're not arguing, Your Honor, that the evidence was insufficient for a jury to make that finding, simply that they were required to have the option of making a different finding, which would be that the defendant miscalculated what he thought he could do and had done without mortal effects at an earlier time.
In other words, the lesson is keep trying and see how far you can go without actually causing death.
I don't think anyone would ask anyone to draw that lesson from this series of events, Your Honor, but that it is in fact the case that in this situation, this chain of events had happened up to a point, and that the jury should have been allowed to consider whether it had a reasonable doubt concerning whether that's what the defendant was intending to do this time. And so then what we would have would be a death caused by very reckless conduct or by a battery. And the evidence is not really disputed about that. The evidence of the earlier event is admitted by the Commonwealth over the defendant's objection, but it is there in the case to be considered. And it should have been there in the case for the jury to consider in terms of having an instruction. And I should say that to some extent, this doesn't necessarily fall into the category of purely formal issues when one considers that the jury was unable to arrive at a verdict, or at least delivered no verdict, as to premeditation in terms of the first-degree murder.
If I could turn you to the extreme atrocity and cruelty argument you make. I don't quite understand why it would be problematic if the consequence of our existing case law is that in most cases the strangulation of a person would be viewed as extreme atrocity or cruelty. I mean, I guess my question is, would you say that it's unfair if a chainsaw murder generally produced a finding of extreme atrocity and cruelty? I mean, the nature of how one dies in strangulation would suggest something that would be extreme atrocity and cruelty. Why is that a problem?
Well, the Commonwealth's position is not that most would qualify. The Commonwealth's position is that all strangulations are potentially cruel, extreme atrocity.
Are potentially.
The difficulty with that line of reasoning is that, in a sense, it mimics halfway what happens in a capital sentencing statute in a bifurcated proceeding. In that situation, someone is qualified for the death sentence, then a discretionary sentencing proceeding happens. If that were the law here, there would be no problem with that. And our position is that this case proceeds almost as if that is the law, that you have a finding of a strangulation, and then you have a kind of discretionary Rorschach test about which of these strangulations is extreme in its atrocity and cruelty.
But isn't that what we essentially have in all cases? We have it's first-degree murder, and then, well, you make the finding as, the jury makes the finding as to extreme atrocity and cruelty in all cases to determine whether it will be first-degree murder. So I don't see how this differs from the normal case.
Well, the difference between this case and in trying to address Justice Gantz's question is that extreme atrocity and cruelty is a requirement of the substantive criminal law, not a discretionary sentencing factor that could be approached in different ways. The court is not in a position to read the word extreme out of this statute, and there has to be a reason to discriminate one case from another in terms of its extremity.
That the Canine factors don't require the Apprendi versus New Jersey approach. One of the Canine factors is the degree of suffering endured by the victim. I think certainly you would agree that someone who suffers for 90 seconds while being strangled suffers more than someone who's shot one time and dies instantly.
Yes, but I also believe that it's quite true that it's not a requirement that every murder by strangulation is extreme. And so the question is,
maybe it is.
Is there something in this? Well, perhaps
I don't know enough about the science, but if the medical examiner says that it takes anybody 90 seconds to die by strangulation, I would say pretty much any I mean, I don't know, because I don't know if that's true. I mean, I imagine there are some where you could break someone's neck instantly, but I don't know.
In order, our position is that in order for the Commonwealth to succeed on this issue, the court would have to announce that rule, that every strangulation is extreme.
No, a strangulation in which someone suffers for 90 seconds, the jury can find.
Well, but remember that we have no evidence in this case that, except the medical examiner reasoning backward from the fact of strangulation to what the process of strangulation would be. So, in fact, in every case where someone is discovered afterwards, it's found that they are strangled, the medical examiner can and must testify that the mechanism of death in this case would require 90 minutes of
90 seconds.
Strangulation. Seconds, I'm sorry, yes. And so the difficulty in doing it this way, in having all strangulations qualified as extreme and then sorting out which ones will eventually be chosen that way, is that as a sentencing proceeding, as a discretionary sentencing proceeding for sorting the horribly cruel and atrocious from the extremely cruel and atrocious, you don't have the protections that you have in a discretionary sentencing phase, for example, of a capital trial. You don't have the defendant's ability to allocute. You don't have the ability to bring in information about the defendant. What I believe can well have happened in this case, and which will happen in other cases unless the court is insistent that extreme is still part of the statute, and that the fact that you don't need unanimous findings about a specific Canine factor doesn't mean that you can do this without evidence of a Canine factor, is that a very attractive person was killed by a man who, if the evidence were to be believed, behaved like a swine, the homicide aside. And you can well have, unless the court is rigorous about requiring sufficiency of evidence of extremity in these homicides, situations where all sorts of factors regarding the attractiveness of the victim, the unattractiveness of the defendant, the criminal record of the defendant, or on the other hand, the youth of the defendant, that should not be substantive criminal law factors, but are adequately based sentencing, discretionary sentencing factors, will press themselves upon the jury and be misused. There are many things that a jury would want to use in deciding in lay terms what's cruel and atrocious that are not suitable substantive criminal law requirements. Although the Canine factors aren't required to have Apprendi-style unanimity, they're nevertheless part of the substantive criminal law that this must be an extreme and an atrocious, extreme in its atrocity and cruelty. If there are no further questions, I see that my time is.
Thank you, Mr. Doyle.
Good morning, Your Honors. My name is
Morning,
Loretta
Ms.
Lilios.
Lilios.
I'm an Assistant District Attorney with Middlesex, and there is nothing about murder by manual strangulation that should automatically preclude jurors from being able to consider it as extremely atrocious or cruel. And so,
Well, as far as I'm concerned, almost all murders are atrocious and cruel. What is extreme about this? What in the medical examiner's testimony makes this stand out as something that was extreme, as we have sort of come to view this category of first-degree murder as opposed to second-degree murder?
well, under the Lattimore standard and taking all reasonable inferences in favor of the Commonwealth, on the first two Canine factors alone, that would be more than ample evidence presented at the trial to sustain this verdict. The first factor being the indifference of the defendant to the victim's suffering.
How is there evidence of indifference other than the medical examiner saying it probably took 90 seconds because that's what strangulations take?
The prolonged nature of inflicting that sort of injury on an individual, seeing the suffering firsthand, face to face, and within one's own hands with an individual that is one's own wife.
So you're
And-
saying essentially you're saying every strangulation, because every strangulation will involve some face-to-face or close contact between two people.
I do believe that, assuming that that sort of evidence is elicited at trial, that yes, that factor alone would be sufficient to qualify that sort of death as one that a jury should consider.
And how is that indifferent from just shooting someone? That certainly shows indifference.
The opportunity for the defendant to view this individual losing her life for this prolonged period, and here we had more than that. The indifference also shown by the testimony that an individual was likely to survive even after losing consciousness if medical help were obtained, and this particular defendant, there was evidence that he had choked her to unconsciousness before and knew that she survived and still did not obtain medical help, as well as indifference shown by then moving on to stage the scene and then turning to, of course, the flip side of it from the victim's point of view, the extensive agony for that period of time, losing one's life at the hands of one's husband with all of his force being applied to her, knowing that, again, in the light most favorable to the Commonwealth, that she did struggle through this. I would say that the physical and mental anguish was sufficient. But really that the question is not so much whether murder by strangulation always qualifies under extreme atrocity or cruelty, but it's whether a reasonable juror, whether murder by this method qualifies as extremely atrocious or cruel. And
I didn't quite follow you, Ms. Lilios. You're talking about first-degree murder?
the question is not so much whether this strangulation was any more atrocious or cruel than other strangulations, but whether murder by strangulation can qualify as extremely atrocious or cruel. And even in the recent case of Commonwealth versus Morganti, which this court decided 2 or 3 weeks ago, which did involve a single gunshot wound to the head inflicted from the back seat to the front seat of the car, the court sustained that under 33E review as extremely atrocious or cruel. To the extent that the court may be questioning this matter, I'd say that there is no likelihood of any miscarriage of justice because murder by strangulation is murder in the first degree. And the fact that the jury did not check off the deliberate premeditation box is not an acquittal here. And I do agree that most murders by strangulation jurors do return verdicts of premeditation, and that would have been particularly expected here, not only because of the episode itself, but because of the apparent planning that the defendant engaged in the month before the crime and alerting many people that his wife was supposedly contemplating suicide. But the jury did not come back that way. So in any event, this was murder in the first degree, and any problem with the extreme atrocity or cruelty aspect of it would create no substantial risk of a miscarriage of justice. And there is nothing in the Cunin factors that invites the jury to infer any kind of bad character. In fact, especially in this case, as in most cases where the judge is very clear about during the empanelment process to weed out any sort of bias, but also in his final instructions to caution the jury that they must not be driven by any kind of pity, sympathy, emotion, or prejudice in their verdict.
Ms. Lilios, could we just go to the so-called spontaneous utterance, and could you just look at that question through the lens of Crawford?
Yes, Your Honor. That incident occurred 5 months before the murder, and the victim first telephoned her father from the phone booth. And
so this is all hearsay, correct?
Yes, her statement was all hearsay.
So we know under Crawford, we now know there needs a very, very close scrutiny of how this is coming in, correct?
That's correct.
So we know that spontaneous utterances are one possible way, correct?
Right. We have to look at whether her statements were testimonial. And they were not testimonial per se, because they were not made in an affidavit or under oath at a hearing or subject to police interrogation. So the question then becomes whether they were testimonial in fact. And I would first of all alert the court that defense counsel at trial agreed that they were not testimonial in fact, and he did have the benefit of the 2005 Gonzalez case at that time. And under Commonwealth versus Lau, there is a suggestion that statements made to a family member would not be testimonial in fact, because they do not indicate that the individual was intending any kind of investigation or prosecution. But the defendant's own statements to Mrs. Harvey the following day, she telephoned him the following day and asked him about the incident the previous night, which he admitted, although he minimized and not to the extent of her loss of consciousness. But even his own statements indicated that he knew that the victim was not going to report him to police, because when Mrs. Harvey said to him, "Don't you know she could call police on you for that?" he said, "She'd never call police on me for that."
No, but that's not how we look at it.
Well, it is. Respectfully, Your Honor.
I mean, it's not whether the perpetrator thinks it's going to be testimonial per se. I mean, whether she'll report it.
I see your point, Your Honor, but I respectfully suggest that it is an indication of what the victim viewed, because here was the man who lived with her and knew her as well as anyone, and even he was of the mind that she was not inclined to report him to police, and that her statements themselves bear all the hallmarks of spontaneity, and those requirements are, those threshold requirements are established in order
How
to...
long after the event? We're talking now, Mr. Doyle was focused on the statements made at her father's and mother's home.
No, Your Honor, the way the statements unfolded were that she telephoned the father from the phone booth,
Right?
and those initial statements,
Assume they come in as
Mr. Doyle
spontaneous
agrees
utterances.
that those come
Yeah.
in. The father then arrived 10 minutes later after the phone call, and she made the statements to him on the street. This was 20 minutes after they occurred. And the statements were that she had a fight with the defendant, he took her cell phone, he cut the landline, he blocked her at the front door when she tried to get out, and in a struggle, he choked her and continued to choke her until she
I'm
passed
confused
out.
about one thing. I thought the first set of statements that the victim made to her father were 10 minutes after the event, and the second set of statements was back at the house 20 minutes after. But am I wrong there?
It was my reading of the transcript that the second set of statements were still on the street, that he arrived, she made some statements for him to go up and get the phone from the defendant. He went up, was not able to obtain the phone, came back down. My reading of the transcript was that the second set of statements were when he returned down. In any event,
And
whether-
that was how long after?
20 minutes.
Okay.
Whether they occurred on the street or back at the home, they were 20 minutes. But my point in terms of the whether she had the opportunity to prevaricate, Mr. Harvey did testify that for both sets of statements she was still hysterical. But those threshold requirements of spontaneity are designed to ensure reliability of the statements, that she didn't have the chance to make up a story. The defendant's own statements the next morning to Mrs. Harvey and his statements to police admitting that he choked her corroborate the victim's own statements. So any questions about the reliability of her statements are corroborated by the defendant himself when he admits not once but twice that he did in fact choke her.
Well, that may go to a substantial likelihood of a miscarriage of justice. It doesn't help me with were these spontaneous as a legal matter.
Well, I suggest that they were spontaneous as a legal matter, and
they were objected to, right?
yes, they were.
Okay, so we're
They
not
were
under
objected to.
substantial likelihood. We're under a higher standard.
My point being, Your Honor, that if there is a question about the spontaneity of the victim's statements, that factor.
No, the way you have to look at it is if there's an objection, his statements may come in, right? I'm not suggesting that if you don't admit her statements, you don't get his statements.
Yes, Your Honor.
You can't make a determination about the admissibility of her statements by looking at his statements.
And under the substantial likelihood standard, certainly they
But
would
if they
be.
were objected to, then it's a higher standard.
And under,
And Mr. Doyle is saying, and this was very, very important.
this was highly probative evidence, I would suggest, in contrary to the defense argument, because it did show extreme.
No,
and
it is highly probative, and therefore, if you can't establish that it was spontaneous under the legal ruling, then it's hard to see why it's not prejudicial.
Well, it is prejudicial, Your Honor. I mean, it is also.
Of course, it's prejudicial.
But in terms of the balancing that the judge did within his own discretion, it also was highly probative, because without this evidence.
No, I understand that. But the question is, does it qualify as a spontaneous utterance? In other words, what's the best case that you have?
Well, Commonwealth versus Snell, which the trial judge relied on, and from which he drew the limiting instruction, which was a statement of a victim smothered by her husband, a statement that she made, I believe, 18 months prior to the murder, when she went to her neighbor's house and said that her husband had just tried to smother her.
No.
How long after the event was, do you recall how long after the event the statement was in Snell?
It was within minutes of the occurrence.
Yeah, but that's
And
not.
this,
I'm focusing on the spontaneity of it. 20 minutes is a long time.
20 minutes falls well within the case law, especially where the testimony was consistent that for both sets of statements, her state of mind was crying, hysterical, still hysterical for the second group of statements, and angry. And in terms of the probative value, without this testimony, really what you had in
You don't
terms
have
of...
to, at least for me, I understand the probative value of it.
Why don't you finish that, Bill, for me?
Thank you, Your Honor. I would like to point out that the defendant himself, when confronted by Mrs. Harvey about those statements, he shed light on what his state of mind was towards his wife, because he specifically said, "She's hard to live with. She gives me a hard time when I ask her for money, and I'm not used to being treated by any woman that way." And without this evidence, what you would have had would have been an unfaithful husband. And infidelity does not automatically give rise to a desire to murder. But his statement, which is inextricably tied to the incident 5 months prior, does give compelling evidence of his settled ill will towards his wife. And for all of these reasons, if there's no further...
I do have
Yes,
one
Your
question. The DNA evidence that came in?
There was DNA evidence found under the victim's left hand, which the Commonwealth argued went to show her struggling.
And what was the nature of the DNA testimony, expert testimony?
That DNA was found under the fingernail on a left hand of the victim, and the defendant's DNA was not inconsistent with that. There was also additional DNA.
And what were the underlying facts? I mean, I can see this in the record of why it was not inconsistent.
Only a partial profile was able to be developed, not a full profile. So there was not evidence that it was a definite match, but he could not be excluded, I believe was the testimony.
Was there any statistical evidence as to in what number of cases?
No, there was not. The nature of it was that he could not be excluded. There was an additional sample submitted for analysis, but the testimony was there was not enough of a sample to give any kinds of results on the additional amount.
In regard to the time of this statement, are you familiar with the case, I think Grant, a 1994 case where there were two shooting victims, one of whom survived and spoke to police an hour later, and I believe we said there that statement was properly admitted as a spontaneous utterance. And also a case of Marshall in 01 where a statement 2 hours after the altercation was admitted. So that might indicate, I don't know if you're familiar with the facts of those.
Yes, Your Honor, and I believe that the key inquiry there is that it's not so much the amount of time that has lapsed,
But the
whether the
reaction of the
victim is
speaker.
still under the influence of the event. I'd ask, yes.
If I could have one more, with regard to the glass of water next to her body, is there anything in the record indicate why that was not fingerprinted?
I think the inference would be that it would be expected that the victim's and defendant's fingerprints would be on that, regardless of that it wouldn't further it would not have furthered the Commonwealth's case if the defendant's fingerprints had been found
Because
on
he
that
lived
glass.
in the apartment, and it would be
Correct.
expected that his prints would be on it anyway.
Correct.
Well, what if someone else's prints were on it? That's the point, I guess.
And that was argued by the defense at trial.
Oh, So you wouldn't want to know, as an investigator, you wouldn't want to know whose prints were on that glass found right next to the person, the victim?
Well, given what, in my view, was a comprehensive investigation of the case and cost-benefit relations that are...
Suggests to me that the first thing you see is things that obviously are very closely related to what happened here and who was involved. The glass has got to be one of the most obvious ones. And unless you've already made up your mind that it's probably someone who lived in the apartment, why isn't that the first thing you'd want to do, is to see who else might have been in that apartment at or about the time when this occurred?
I suppose it was not the first thing that the investigators wanted to do because the door was locked when the victim was inside. The defendant was the only known one with the key. Even her own parents didn't have a key. And
Suggests she may have let someone in. That's not unusual either.
Your Honor, I would suggest that based on the evidence that the jury were more than warranted in their verdict and that this was an item that was argued extensively by the defense. I'd ask you to affirm the conviction. Thank you, Your Honors.
Thank you, Ms. Lilios.